Hi, and welcome to the Law Simplified. I'm Shavin Bandarnayaka. Welcome to our third edition in relation to the live Q&A series. This one is on public law, or we could call it constitutional law, administrative law at that as well. First and foremost, I hope everyone is doing well and staying safe in this new normal that we are living in around the world. The origin of these live Q&A sessions also primarily is because although law is something that each of us can study and prepare for in isolation, it makes it much more enjoyable when it's a community experience, so to speak, when all of us get together and prepare for assignment submissions or examinations together. So this particular series of live Q&As, we've already done two thus far, criminal law as well as contract law. You can have a look at those recordings in a playlist on this very channel under live Q&A. This too will be incorporated to that for those who are not joining with us today. But for those of you who are, welcome to the live Q&A series. This edition is that of public law. I appreciate everyone joining me today as well. We are in the process of trying to build this platform in such a way that it helps as many law students as possible around the world. Now, for those of you who haven't joined us for the previous Q&A sessions, this Q&A series is primarily targeted at going through a fast track, so to speak, of the theory of any given subject. So today, for example, we're going to go through public law. It's going to be a hefty fast track in the sense that with the limited amount of time that we have available, we'll try to touch base on the fundamentals of this subject, how to look at it from the perspective of an examination, what exactly you need to think of when you are studying this, and how to supplement and substantiate whatever that you want to do essentially with this subject, be it academically or professionally. Now, once this is completed, as you know, we have a Q&A section. This will be about 2/3 of our session is dedicated to the question and answers. Essentially, you can use the chat box, the live chat box that's available on this very platform. And once we are done with the theory, which we'll go through within about 10 or 15 minutes, the remainder of our time will be dedicated towards looking at the different questions that all of you might have. Right now itself, I do see some questions coming up as well. Do bear with me in the sense that we'll go through the theory for the benefit of those who are joining us at the very inception, and then we'll go through the question. We have one question already from Jared. Just to quickly answer that, because it is relevant to what you're going through here in terms of the Q&As. Yes, whatever the lessons that you see on this channel are applicable to any common law LLB degree, be it the University of London or any other university out there in terms of the common law LLB jurisdiction. But that was just to outline that very quick question that Jared had. But whatever questions that you do have, make sure you post it on the chat box, the live chat box. And once we are done with the theory, we'll go through those as well. Let's give it a minute or so that the others can join us as well. I do see several concurrent viewers at the moment, but let's give it a minute or so. To continue on the outline of this subject matter that I wanted to get through, these live Q&A sessions are intended not to be a comprehensive set of material, let's say theory, or even in a tutorial context of any subject. Rather, it's meant to give you a broad stroke understanding, a bird's eye picture, so to speak, of the subject itself. So you'll get an understanding of the topic outline, how you should think about the subject when you're tackling it, as well as maybe in an examination context. So whatever the questions you may have, make sure that you understand that there is a limit to what these sessions can do, because I've gotten a number of questions on that level. If you want to learn further, there are other resources that are available on this very channel, or you can have a look at my online law school platform, which you can access through the links in the description to this video, or simply by going to courses.thelawsimplified.com. There are several pre-recorded masterclasses as well as fast-track sessions. There are workshops. It's plentiful, so to speak, with content to substantiate your learning as well, and it'll be much more useful than essentially me going through each and every aspect in terms of the Q&As. But this is a good start for you to prepare for your examinations. We do have a few of y'all joining in, so I think we're good to go. Well, let's start off with the theory component of our live Q&A session for public law. To begin with, let me first outline and position this subject in the grander scheme of the LLB, GDL, or any other law qualification that you're doing. By and large, if you are going through constitutional law or public law, it is one which essentially looks at the governance and the functioning of a country. There are many ways in which you can define this subject or what exactly it goes through. But the one way that I like to consider constitutional law, public law, is being essentially the rule book by which a country is governed, and how the law itself facilitates the functioning in an orderly manner. Now, in whichever syllabus that you are accustomed to, when you go through constitutional law, when you go through public law, you would notice that there are a certain set of topics that you would encounter. Generally speaking, a succinct LLB or a particular syllabus in the English common law would go through topics such as the Constitution of the UK, separation of powers, rule of law, parliamentary sovereignty, Parliament itself, privileges, the royal prerogative, judicial review, and human rights. Now, these broad areas of the law, so to speak, consider different aspects of the subject that you need to understand before you get an idea of the entirety of the subject. What I mean by that is, when you go through subjects such as, let's say, contract law or criminal law, general level 4 subjects, your introduction or foundations of the law, what you would normally encounter and notice is the fact that these are somewhat sequential in nature. Generally speaking, if you are answering a question in contract law, for instance, you will understand that a contract entails an offer on the one part and an acceptance on the other, and then that being substantiated by consideration, forming a contract. Afterwards, you look at the function or the operation of it by virtue of terms and regulation of terms, and then determine if any sort of breach has happened that might lead to termination or damages. Same thing with criminal law. You look at the actus reus and the mens rea, whether those things have been fulfilled. Anything that's missing, that will entail the prosecution not being able to prove beyond reasonable doubt that a defendant has done something, defenses that align with that, and then so on. But when it comes to public law or constitutional law, the circumstance is somewhat different. Because when we think of public law, we have to look at different aspects of governance and different aspects of the law and the country at large to determine the rules that are in place. Now, the UK specifically has a very unique position in relation to this subject, primarily due to the fact that the UK has what we call an uncodified or an unwritten constitution. The very nature of the UK's constitution is such that it is not found in one solid place. It is derived from multiple legal and non-legal sources. Now, this creates a unique situation for the UK in which at one point or the other, certain circumstances that are subject or that subjected UK in its history have molded or shaped the UK's constitution. And it's very important in that context to look through the constitution as a topic and the various nuances that affect it in some way, shape, or form. So when we look at topics like the constitution, it's more explorative, so to speak, rather than really argumentative as such. But the constitution as a topic is very important in the grander scheme of public law, in terms of constitutional law, because you can think of this as being the lifeblood or the connecting factor to every other topic out there. When we talk about rule of law, when we talk about separation of powers, parliamentary sovereignty, all of this stems from the fact that the UK has an uncodified constitution, one that is very different from other countries as well. Have a look at some of the lessons on constitutional law, which is there as a playlist on this particular channel as well, to get a broader understanding of that, and maybe even the pre-recorded fast track or the masterclasses on my online law school platform. You can reach those, or you can have access to those through the links in the description. But having said that, getting back to the topic of constitution, primarily the way that we identify and distinguish the UK's constitution from that of every other country, most other countries rather, is the fact that it's not derived from one place. It is sourced from multiple locations, and because of this, it creates a very fluid, a very dynamic constitution at that. UK has a very unique situation in which we call this as much as indicated rather by Griffith on a number of occasions to be what is called a political constitution. What that means is it's so fluid and it's amenable, or much more amenable than a written codified constitution, that politicians are capable of giving effect to campaign promises, so to speak. But having said that, this is our foundation or the entry point to this particular subject, the Constitution of the UK. Once we understand this, and it's important to recognize this as well, depending on the topic that you are doing, there will be several topics in public law that are specific towards the UK as well. So generally speaking, aspects of separation of powers, aspects of rule of law, even for the great extent parliamentary sovereignty and parliament, could be considered as being general world over. In other words, whichever country that you might be from, or whichever country that you try to put this into context in, that's similar in terms of its operation and functionality. But specific topics like constitution, a sub-area at that which is conventions, royal prerogative, these topics are very specific, let's say, to the UK. In some functionality, there is a counterpart in other countries. For example, a topic like royal prerogative can see a counterpart in executive authority or executive orders, like that which you see by virtue of executive presidencies in different countries. So it's called something else, but the functionality remains somewhat similar. But the UK is in a unique position because if you define the UK in terms of its constitution, it is somewhat monarchical, while being questionably unitary and of course uncodified or unwritten. Now, having said that, looking at some of these general topics, such as for instance separation of powers, you'll notice that this deals mostly with determining how exactly the three arms of government, namely the legislature, the executive and the judiciary, are independent as well as interdependent. Now, when we talk about separation of powers, our focus is primarily on two aspects. One is the relationship that exists between these three arms, namely that of the executive and the legislature, the executive and the judiciary, and the legislature and the judiciary. And on the other hand, and I would argue more importantly, the independence of the judiciary. Because 9 out of 10 times when we discuss separation of powers, we actually discuss the concepts of independence of the judiciary as opposed to anything else. The interdependence between the legislature and the executive is quite normal. In fact, it is welcomed. The fact that ministers or members of parliament as well as members of the executive, the cabinet of ministers, should work with one another is paramount to the functioning of a country. Without the ability to do so, what happens is you will have one hand not knowing what the other is supposed to do, essentially. So this interdependence and independence is what we primarily focus on when we talk about the topic of separation of powers. Now, the UK has a very unique spin on this as well, again, stemming from the fact that the UK has an unwritten or an uncodified constitution. This very uncodified nature of the constitution means that this independence and the interdependence between these three arms of government are at times somewhat questionable. Things change, it's very fluid as such, which leads us to one of the most pivotal topics as well, one which is normal in the context of not just in the context of the UK, but specifically in the context of the UK, which is the rule of law. Now, you will notice, for instance, in examination contexts, situations in which the rule of law is the only guiding principle or the guiding light to circumstances in which you might not have something set in stone in writing to specify that being the way it should be done. Now, this has been, for the most part, considered as one of the disadvantages of having an unwritten constitution, one which is uncodified. The uncodified nature of the constitution generally means that you don't have any piece of paper or legislation that is solid enough to suggest to the governance, the policymakers, that this should be how it's done. There is no legal illegal in that context. So because of that, many have suggested that a proper procedure and principle of rule of law is the only thing separating order from chaos. Now, while there are many ways in which we should look at the rule of law, namely more modern context is that which is outlined by the former Chief Justice Tom Bingham. One of the pivotal or the origins of looking at the rule of law are by virtue of the three limbs assessed by Albert Venn Dicey, A.V. Dicey. So Dicey outlined the fact that a country which is operative within the confines of the rule of law is one in which everyone is equal before the law. No person is punished unless he has committed a crime as prescribed by law, and the fact that individual rights, fundamental or human rights, are best protected under common law. Now, having said all of this, one of the major areas in which I see rule of law being misinterpreted and misunderstood by students, since I've gone through hundreds of scripts, hundreds if not thousands of scripts over the past several years, one major flaw that I see in students who answer questions in relation to the rule of law is assessing, or rather misinterpreting, rule of law as being any country which has good or fair law versus unfair law. This is far from the truth. Rule of law is, and I have to stress on this as well, is a relative concept. What I mean by that is, when we say rule of law, we are looking at whether, by and large, the law is equivalently spread out and applied to everyone in an equal manner. And on top of that, especially when we look at the second limb, namely the fact that no one should be punished if he or she has not committed a crime as prescribed by the law, we are not looking at whether the law is good or bad. We are looking at whether the law is what the law as it is considered in that country. So, for example, if you take punishment, if the punishment in that particular country for murder is life imprisonment, then you can be punished only by virtue of that. If it is that of the death penalty, or let's say stoning or beheading or strangulation or lethal injection, whichever way, that punishment is what the country has identified as being the valid punishment for that crime. So rule of law does not care or consider whether the law itself is fair or not. It's just whether that law is being applied in the correct manner, whether a person is being punished by virtue of the fact that he's breaking that law or not. So this is something that I often stress to students in my fast track and master classes as well. Rule of law is not about the right or wrong or fair or unfair. It's whether there is equality in the application of the law of that country. Now, another quite important topic and an area in relation to public law, specific towards the UK, is that of parliamentary sovereignty. Specifically, the absence of a written constitution, of a codified constitution, means that Parliament has become quite supreme. If you think of it as a hierarchy and an order by which things happen in the UK, it would essentially stem downwards from, or trickles downwards from, Parliament. So legislature or Parliament essentially passes law, which is executed by the executive and interpreted by the judiciary to determine if the powers were used properly, or so on and so forth. Now, parliamentary sovereignty, much like rule of law, is also defined in terms of its parameters by A.V. Dicey, and we look at Dicey quite significantly here, not mostly in the context of what he has said, but rather the critiques of it over time. When using Dicey, you have to use him with a pinch of salt, so to speak, considering the fact that the world has moved on and is a much different place than what it was when Dicey considered these notions. One major example of this is Brexit, which took place recently, and the UK now no longer being part of the European Union. The irony, however, is that when Dicey spoke about parliamentary sovereignty and his three limbs at that, the UK was not part of the EU in the first place. So these principles would stand true today more than ever before in that context. Now, having looked at parliamentary sovereignty and considering the time factor that we have as well, and I do see a few questions trickling in also, we'll have a look at finally the aspects which are very specific towards the UK, which is the royal prerogative. Now, one might argue that the royal prerogative is a situation in which you cannot essentially connect it, so to speak, with any other area of the law in any other country for that matter. But the reality is that you can consider the royal prerogative as the powers which the executive has, in which they can act according to their will as opposed to a power granted to them by virtue of an act of parliament. In other words, the basic premise here is they are able to facilitate actions in which they don't have to have the concurrence of the House of Commons and the House of Lords, or the Parliament at that. Now, why this is important has been debated as well as criticized, but generally speaking, you can consider the royal prerogative, as misleading as that terminology is, because in reality it's not the Queen or the Crown that wields this power, that is by virtue of office. Rather, it's the executive, the Prime Minister and the Cabinet of Ministers that goes on to use this. Now, when we look at the aspects of royal prerogative, the most important thing to understand, or to recognize rather, is its application in the modern world. When we think about the royal prerogative, I always consider it as being a one-way street. The royal prerogative could be considered to have originated as the powers vested with the crown or with the king at the turn of the century in the context of the Norman conquest. So these powers have slowly but steadily reduced over time until now. It is only a handful of powers that the prerogative, or rather the crown has, whilst most of it has now been taken over by Parliament. Now, what I mean by saying that it's a one-way street is because new prerogative powers cannot be created. These are not ones which are codified, that can be referenced. These are by virtue of tradition, essentially. Many students tend to get royal prerogative as well as conventions somewhat confused. Conventions are traditions in the context of doing certain things in the way that they used to, or they used to always happen, whereas prerogatives are powers. Not following or breaking a prerogative is illegal, as opposed to a breaking of a convention or a tradition is unconstitutional. One lands you in jail or a great deal of hurt, and the other you are frowned upon, essentially. But digressing on that, when we talk about the royal prerogative as an area of law, when we talk about its application, much like in terms of separation of powers, we look at how the application and the use of the royal prerogative is controlled by the other arms of government. Because royal prerogative is fundamentally used by the executive, which means the control of it will have to be by virtue of the legislature and the judiciary. Right. Now, that being said, and having gone through the fast track theory components of public law, of constitutional law, this is a vast subject. It's an area in which not only would there be a lot of questions that are posed to you, but there is opportunity for arguments and critiques. Now, what I mean by the opportunities for arguments and critiques is because the examination will fundamentally focus on your ability to articulate arguments based on not just the question posed to you in an essay format, but also your current knowledge as well. This is something that most students tend not to really focus on, especially during such a time as this. Post-Brexit, the UK has seen tectonic shifts that have taken place in their governance. And whether it be in terms of the constitution as a topic, rule of law, separation of powers at that even, there are many changes that have happened in terms of the application and the operations of the law, which you should take cognizance of and maybe consider the next time that you answer questions. Okay. Now that we've gone through the fast track theory, I'm going to go through some of the questions that have been posed on the chat box. So let's have a look and see. I think I already answered the first one. So just to reiterate for those who didn't join, whatever the lessons that we have in response to Jared, essentially, whatever the questions or whatever the lessons that are there on this very YouTube channel, my courses on Udemy, the mini courses, as well as the brand new platform where I have pre-recorded masterclasses, fast track courses, hours and hours of workshops, as well as one-on-one sessions with other students from around the world. All of this content and also the supplementary material like the spider graphs, the case summaries, all of them are based on the common law, specifically the UK jurisdiction. So whichever UK LLB, GDL, or A-level even program that you're following, to some degree, it's applicable to those. So yes, whichever university it is applicable to that. I think there's one specific towards international law as well. Let's see. To what extent is erga omnes applied today in international law? Prince, unfortunately, I'm not able to answer that question in the context of public law as such, because it's essentially a cross-section between three subjects you're asking me. Public international law, administrative law, as well as constitutional law. But in general, talking about erga omnes, it's one way or the other in terms of the application of such principles. Generally speaking, if you think of it in a jurisprudential context, you wouldn't really apply it considering the liberal mindset now. But it depends, again, on a cross-section. Whenever you have applications of such principles, the idea is really twofold. I think of it as being horizontal and vertical, on a plane of time as well as geography or demographic. So something which is perhaps not really considered in one part of the world might be the case somewhere else. So if I'm to distill your principle, the Latin principle, essentially towards all, or it means the application to everyone, Yes, it is the case in many democracies, in many liberal societies, but you still do have quite authoritarian and quite strict nationalities or particular countries in which the application is more one-sided, as opposed to rights being conferred to people, rather they are being forced to do things. Positivism over that of sociological. But this might not be the best forum for that question, since it cuts across many aspects, and since I prefer to keep it within the context of our Q&A, that's as far as I can go. Then we have another question by Jess. Quasi-judicial control of the administrative bodies and how. So first we need to break down what you are considering here, because when we say quasi-judicial, generally it refers to aspects of things which are delegated out as opposed to any particular judicial process. So for instance, you can think of a very specific tribunal that has been set up, or you can think of an administrative body that's out there specifically, like a select committee. Let's say, for example, the Parliament sets up a select committee to look into an aspect of malfeasance or malpractice at that. Now, these, on the one hand, these particular quasi-judicial entities, these committees that have been built, are on the one hand specifically towards a particular endeavor. So it might be for the purposes that committee was actually built for. And that being said, it is also time barred. So by virtue of that, you have a very limited run of such committees that is established for a purpose. It creates an outcome, or it suggests an outcome, and then it's disbanded. Now, when we think about quasi-judicial entities, ones that are specifically made towards controlling administrative bodies, you need to think of it in its limitations of jurisdiction and time. Most quasi-judicial bodies are intended to provide a direction as opposed to, let's say, punishment or remedies. You can think of them as being very similar to arbitral bodies like ADR, mostly towards alternative dispute resolution methods. In other words, much like in arbitration or mediation, you'll have circumstances in which decisions are made out of court, but still, in order to enforce such outcomes, you still need to seek the redress of a court of law. I hope that somewhat answers your question, Jess. The beauty of public law or constitutional law is such that it's essentially intersecting with many other topics as well. Now, you can't say the same thing with contract law or criminal law. Perhaps a little bit with contract law, since you do have level 5 and 6 modules such as commercial law, company law, intellectual property that have some link to this. But every other subject area, be it property, be it criminal law, has a somewhat unique island mentality, so to speak, in its application. But constitutional law is such that the very argumentative and critical nature of it means that you will have it intersecting with public international law, European Union law, administrative law, which is a intersect and a heavy, let's say, a moving forward factor, so to speak, for public law. And one of the most fundamentally interesting subjects, one which I enjoy quite predominantly, which is jurisprudence. Jurisprudence in itself is not even a subject that in terms of the law, it's mostly about how to look at the law as such. Okay, having said that, since we have a limited number of questions today, either by virtue of the fact that it is a subject that everyone is clear on, or the fact that the questions are mostly geared, much like I said, towards different areas of the law and intersects as opposed to one particular thing, I think we are good to cover and complete our session for today. Please do make sure that you subscribe to the Law Simplified for more live sessions, as well as the weekly videos on examination technique and how best you can study and prepare for your upcoming assignment submissions. That will happen on this channel as well. Have a look at my brand new platform, which has pre-recorded masterclasses and fast-track programs. You can find the links in the description below, or simply visit courses.thelawsimplified.com. Thank you ever so much for joining, and do join in for the next few sessions that happen on a weekly basis on Sunday, 9:30 a.m. GMT. But specifically during this time, stay safe and make sure that you keep well and prepare for your upcoming assignments and examinations. But until the next time that we meet, have fun, stay safe, and as always, obey the law. Cheers, everyone.